My route to the bench has been very unusual, to put it mildly. After I graduated, I went straight into university teaching. I did that for 2 or 3 reasons. First, I'd spent my long vacs as a student working in solicitors' offices as what would now be called an intern, one in a major London firm, so I saw the benefits or disadvantages of big city practice, and the other in our little local firm of solicitors up in North Yorkshire. I was fortunate enough to be offered a job by the University of Manchester, and they wanted me to qualify as a barrister while I was teaching in Manchester and then do some part-time practice. They thought that would make my teaching better, as indeed it did, and I thought that sounds like the best of both worlds. Soon after I got to Manchester, I joined Gray's Inn. Gray's Inn is a very lively, friendly, unstuffy place. I chose to join Gray's Inn because I knew people who were already members of the inn. That is, I think, in those days, the main reason why people chose to join a particular inn. I passed my bar finals in 1967, very soon after I had joined the inn. The call ceremony in those days was very different from how it is now, and it depended upon the person who is the senior in hall what form things took. And in our case, the senior in hall required every single person who was being called to the bar to make a speech. You can imagine what that was like, especially by the time we got to the end. It was pretty rowdy, pretty unruly, and quite a lot of drink had been taken. But I think we all remembered it pretty well and were proud to have been called to the bar. I qualified eventually as a barrister, and I was fortunate enough to get a pupillage in a good set of Manchester chambers. I was told that my pupil master did not approve of women at the bar. Halfway through my pupillage, I plucked up courage and I asked him why he didn't approve of women at the bar. His wife was a doctor, after all, so he couldn't disapprove of professional women. And he said, well, that's fine. Medicine is a caring profession. And of course, women should care and can care and do care. But the bar, he said, is a fighting profession, and women shouldn't fight. Not only that, they couldn't fight. They were either too yielding or too obstinate. Well, of course, he was right about the bar. It is a fighting profession, and you have to have the judgment about what to fight and what not to fight, when to settle a case and when to insist on a hearing. But he was wrong, entirely wrong, about women, because of course women can make those judgments just as well as men can do. University teaching is one of the most rewarding jobs that there is. But after I'd been in part-time practice at the General Common Law Bar in Manchester for a while, also teaching students at the university, I had to choose between them. You couldn't go on doing both. Your commitment to the students got in the way of doing the longer cases, the better cases. And of course, your doing any cases at all got in the way of the research and writing that you have to do as a successful academic. And for a variety of reasons, I chose to stay full-time in academia. I'm not sorry I did that, but at the time it never occurred to me that I would end up as any sort of judge. The two things that I'm most proud of are, firstly, the projects which my team engaged in at the Law Commission, which resulted in legislation. There's the Children Act 1989, there's the Family Law Act 1996, and there's the Mental Capacity Act 2005, all of them big projects which came to fruition. But of course, I can't be anything other than very proud of becoming the first and only woman Lord of Appeal in Ordinary. That is, a member of the top court for the whole of the United Kingdom, which used to be a committee of the House of Lords and is now the Supreme Court. And of course, as a member of the top court, you get to decide some really interesting and important cases. It will be difficult to pick out my top 10 cases, but I should probably have a desert island list of them one of these days. My route to the bench has been very unusual, to put it mildly. The unusual thing about me, compared with all the other justices in the Supreme Court, is that I have been employed all my life. And that is a very different experience from being in self-employment at the Chambers Bar. There is a structure to it. There is a predictability to what your diary holds. There are more manageable hours, which makes it particularly attractive to people with family or other responsibilities. And the work can be absolutely fascinating. I gather that my brooches have achieved a certain notoriety. I first started wearing brooches in the family division when I had to wear dark suits, usually black suits, and my husband began to give me brooches in order to liven things up a little. He started with a rather charming, small, antique spider. So I didn't mean any sort of message when I wore a spider in the prorogation case. But then, of course, an enterprising firm decided that they would make a T-shirt featuring the spider. And they raised a lot of money for Shelter, the homelessness charity, which is very dear to my heart. So I think that was a good thing. And yes, I do have one of those T-shirts, but I only wear it on occasions when it doesn't look as if I'm going to be giving any sort of message from it. I also, as a High Court judge, became automatically a member of the bench of Gray's Inn, and eventually in 2016 I became Vice Treasurer, and then in 2017 Treasurer. And these are wonderful roles because you get to meet so many of the students who joined Gray's Inn. It was like being a university teacher all over again, encountering these bright young minds and hoping to shape their views of the future as well. And perhaps to let them know that it was possible that a little girl from a small town in North Yorkshire, state educated, no particular contacts, in fact no contacts at all at the bar, could nevertheless make it to the top of the justice system.